Hello everyone, my name is Vivek Tripathi and today I'll be discussing about the Re-Berubari Union Case 1960. In a summarized form, I would like to say that in this case, the Supreme Court said that the preamble is not the part of the Constitution and because of that reason, preamble has no substantive power. So now let us see what does this case has to say about its facts. The states of Punjab and the Bengal were to be portioned and the commission of Sir Cyril Redcliffe as a chairman was appointed. And a boundary was fixed between India and Pakistan, which is also known as Redcliffe Line. Sir Redcliffe was appointed to rest the districts of Jalpaiguri between two countries by giving some thanas to India while remaining thanas to Pakistan. So basically, I would like to inform you that Jalpaiguri was a district which was a part of India, which was a particularly part of India, and it was located in the particular region that is known as Bengal, which has been divided into Bangladesh and West Bengal. So there was a district known as Jalpaiguri and it has several thanas. So during the process, he here refers to the Sir Cyril Redcliffe. He omitted one thana that is known as Berubari. Berubari Union number 12, and later it was awarded to India on 12th August 1947. Now moving on forward, the omission made by the commission and the erroneous, that means the not correct depiction on the map, given the Pakistan an opportunity or the liberty to claim the territory on its own, as its own. So during all this process was underway, the Indian Constitution came into force on 26 January 1950. And Article 1 of our Constitution provided that India shall be the union of states and shall be mentioned in Part A, B and C of the first schedule of the Constitution. Now West Bengal was included in Part A of the Constitution and Berubari was included in it as it was awarded by the Boundary Commission to India. The Pakistani government contended its claim over all the Berubari Union for the first time in 1958. So the Pakistan here wanted the whole Berubari under his own control. Just because of the two reasons. Firstly, it was the omitted by the commission itself, because the commission omitted it to divide between the two states, that is India and the Pakistan. And secondly, the non-correct description or the non-correct depiction of that particular Berubari on the map itself gave the opportunity to Pakistan to claim the Berubari or the territory on it as its own. So what happened? The dispute was resolved. So the dispute was resolved in 1958, an agreement wherein the northern part was allotted to India, the northern part was allotted to India, and the southern part was allotted to Pakistan. And the agreement was made and it was known as Nehru-Noon Agreement. The Prime Minister of India at that time was Pandit Shri Jawaharlal Nehru and the Pakistan was Feroz Khan Noon. Now let us see what were the contentions of the people of the Berubari or the CM itself. At that time, the CM of the West Bengal was Bidhan Chandra Roy. He got the state assembly to pass a resolution against the illegal demand of the Pakistan. इन्होंने agreement को नकार दिया. And Berubari was a Hindu majority. Friends, Berubari was a Hindu majority and Berubari is a village where more than 12,000 villagers had cut their fingers and wrote to the president. The president that time was Mr. Rajendra Prasad of India. And they said, Amar Rakt Debo, Amar Pran Debo, Berubari Debo na. So we will rather give blood than give Berubari. This was the statement made by all those villagers. And Parliament, they also contended in front of the state that Parliament did not ask while giving the part of the Berubari to Pakistan from the people of the Berubari itself. So now let us see what is the Nehru-Noor Agreement, which is passed in 1958. The Nehru-Noor Agreement 1958 stated that both of them decided to exchange the territories. First point. Secondly, the Berubari Union 12 is divided horizontally, enclave for enclave, to be done and to avoid territorial loss. Now with this, moving on to the next part, that was what were the issues raised in this particular case. So Dr. Rajendra Prasad took the presidential reference under Article 143, Subclause 1 of the Constitution on April 1, 1959 and asked to the Supreme Court of India, first issue, that Is any legislative action necessary for the implementation of the agreement relating to Berubari Union? Second question which he asked was, if so, is a law of parliament relatable to Article 3 of the Constitution sufficient for the purpose, or is an amendment of the Constitution in accordance with Article 368 of the Constitution necessary, in addition, or alternative? Before we go, what were the answers of these issues? Let us see what does Article 3 has to say. So Article 3 says in a simpler terms, in a layman terms, पार्लियामेंट के पास पावर है कि वो कोई नए स्टेट्स बना सकती है, एरियाज स्टेट के कम कर सकती है, बाउंड्री ऑल्टर कर सकती है. ओके, नाउ लेकिन देयर वाज अ कंडीशन, लेकिन कभी भी ये मेंशन नहीं किया कि वो अपना एक पार्ट किसी को दे सकती है या कंट्री को दे सकती है. So with this, moving on to the Article 1, Sub-Clause 3, Clause C. इंडिया अपने एरिया को एड ऑन कर सकती है, लेकिन कम नहीं कर सकती है, क्योंकि ऐसा कोई पावर पार्लियामेंट के पास नहीं है. So when matter reached the Supreme Court, then the arguments raised by the government were, government said, हम कोई भी लैंड को सेसेशन नहीं करेंगे, मतलब कोई हिस्सा नहीं दे रहे हैं, जितना लैंड दे रहे हैं उतना ही लैंड ले रहे हैं. So there is no need of legislative intervention required. मतलब हमको कोई भी लॉ इन लैंड डिस्प्यूट के लिए लाने की जरूरत नहीं है. अब आर्ग्यूमेंट्स तो गवर्नमेंट ने दे दिए, लेकिन अभी आर्ग्यूमेंट्स अगेंस्ट में भी तो आए. तो अगेंस्ट में आर्ग्यूमेंट्स क्या थे? अकॉर्डिंग टू द प्रियम्बल, Parliament has no power to alter the territory of the country. Okay? And secondly, what were the other argument raised? Article 1, 3, subclause C only talks about acquiring the territories and not ceding any territory. यानी टेरिटरी को कम करने की बात आर्टिकल 1 क्लॉज 3 सब क्लॉज C नहीं कहता है. Now let us see what was the judgment of this Re-Berubari Union 1960. फर्स्ट जजमेंट जो आया, जजमेंट के पार्ट्स थे. फर्स्ट पॉइंट ऑफ द जजमेंट वाज पार्लियामेंट सेड दैट preamble is not the part of the constitution. Sorry friends, I would like to correct. The judgment of the court was the preamble is not the part of the constitution. Article 1, subclause 3, clause 3, subclause C only talks about acquiring the territories and not ceding any territory. Third point of the judgment was Article 368 gives power to amend the constitution, hence Article 1 can be amended by Parliament. But amendment has to be brought via Article 368, only then land can be ceded to East Pakistan. East Pakistan, the West Bengal is known as the Bangladesh. The Bangladesh especially is known as your East Pakistan at that time, because that was a part, the Bangladesh was earlier acquired by the Pakistan. That is the region which was given to Pakistan by Sir Cyril Redcliffe during the division of the states. West Bengal is a part of India. Now let us see what is the impact of judgment. Parliament had to make the 9th Amendment 1960 of the Indian Constitution. Okay, and firstly जिसमें ये जो कॉन्स्टिट्यूशन में अमेंडमेंट लाया गया 9th अमेंडमेंट, इसमें शेड्यूल 1 को अमेंड किया गया, साथ ही साथ नेहरू एग्रीमेंट को इंप्लीमेंट किया गया और कुछ एरिया पाकिस्तान को दे दिया गया. 1971 में वॉर हो गई. ईस्ट पाकिस्तान जो था, ईस्ट पाकिस्तान, इट बिकेम बांग्लादेश, एंड फाइनली बेरुबारी बिकेम द पार्ट ऑफ इंडिया अगेन. So with this, thank you everyone.